A very good day to all our listeners. I am Mahesh Revanna, a corporate lawyer and an expert on POSH. I am in conversation with my colleague Kaveri, who is also a corporate lawyer and an external consultant on several ICs. On a very interesting subject, is IC an independent body within the organization? Hey Kaveri, shall we begin?
Hi Mahesh.
Kaveri, you're a part of several ICs and have been a part of several investigations as well. What do you think? Is IC an independent body within the organization?
Of course, Mahesh, and you know it too. The whole intention of setting up an internal committee to handle cases of sexual harassments of women at workplace, specifically excluding the employer who is the final authority to take disciplinary action based on the recommendations of the IC, is to make it an independent body. This is further strengthened with a senior woman heading it, having equal representations of men and women, and most importantly, bringing in an external committee member as well. There is no doubt that the internal committee is independent within the organization. What has been your experience so far, Mahesh?
I agree, Kaveri, that an IC is an independent body within the organization, specifically with respect to cases of sexual harassment against women at workplaces. However, it may be of interest for you and the listeners to hear some interesting cases I have been a part of. I still remember going to an MSME that was known to my uncle, and my uncle had mentioned that he gave a lot of respect to women and he followed the POSH Act to the core. I still remember that day, very eager to know what he was doing at his organization. I had asked, Sir, I understand that you're very particular about enforcing the POSH law. Would love to hear about it. And Pat came his reply. Yes, I'm very clear. If there are any complaints I receive against anyone in the company, I just terminate their services. This left me spellbound.
Oh my god, the very spirit of the act defeated. I remember something very similar too. One of the companies in which I am the external counsel received a complaint of sexual harassment. And while the IC went about with the inquiry process, to its shock, before it commenced the proceedings, the complainant and the respondent came to the committee with the way they wanted to settle the matter. We were rather surprised because just before we commenced the initial discussions, both the complainant and the respondent were in total disagreement, and we wondered how this happened, only to realize that the CEO and the HR head had had a parallel inquiry and had convinced them to settle. As the saying goes, all's well that ends well. In this case, the matter got closed. However, had this escalated just the basis of the employer and the HR having carried out a parallel process, could have exposed the employer and could have made them liable to pay a hefty fine. The crux of the act is once an IC is set up by the employer, the IC should be left to function on its own. Interference by the employer should be discouraged.
True indeed. Do you remember the case of Linda Eastwood versus Union of India? The complainant, Miss Linda Eastwood, had filed a complaint of sexual harassment with the IC against one Mr. M.K. Singh, who was the chief managing director. Mr. M.K. Singh used his position in the organization, interfered in the IC proceedings, and even went to the extent of reconstituting the IC with the members of his choice to get a report in his favor. When the case came before the court said that Mr. M.K. Singh, against whom there were serious charges of sexual harassment, was instrumental in selecting the members of the committee of his choice to get a favorable report. Composition of the second committee was vitiated and flawed. Principles of natural justice were flagrantly violated. Mr. M.K. Singh, being a party, ought not to have taken active part in the decision of formation, constitution of the committee. No sanctity can be attached to the proceedings conducted by the second committee to give a clean chit to Mr. M.K. Singh. The court decided to reconstitute the IC and held that the reconstituted committee shall start its proceedings within 10 days and shall submit its report in a time frame as prescribed under the Act.
Oh, yes, Mahesh, I do remember that case. And the court rightly held that when the IC is unable to function in the way it actually should as per law, with interference from the management, the purpose for which the IC is constituted itself is defeated. The IC is a body constituted under the law for a purpose in an organization. That is, to impartially inquire into a complaint with the powers of a civil court. If there is interference in the manner an IC functions, it kills the whole purpose for which the body is formed.
Let's call it a day then. And listeners, do get in touch with us with your queries, suggestions, and feedback by emailing us at admin@upseedconsulting.com or writing to us on LinkedIn, Twitter, Instagram, or Facebook. We will be back soon with another interesting topic. Wish you all a great day ahead and a happy weekend.